DUI Guide, Chapter 4, what is the legal process you're going to face when you get a DUI charge? Now, I'm going to take you through some really important things that you really should know about as you face your DUI charge. First, what should you expect when going to court for your DUI charge? Now, the most important thing to remember with any criminal charge, whether you've been charged with drinking and driving over 80 or impaired driving by alcohol or drugs or refuse breathalyzer, is that you are presumed innocent, okay? It's the government's job to prove you are guilty beyond a reasonable doubt. You don't need to prove you are innocent. Now, to prove the charges against you, the government must go through a very specific legal process. And this legal process starts with a court date that's called a first appearance. Now, that brings up the question, how long does it take for my criminal charges to proceed against me in the courts? Now, the criminal charges against you are going to take time. Now, this legal process does not happen overnight. However, the courts can't take forever to prosecute the case against you. Generally, the courts have up to 30 months to bring the charges against you to trial. If your case goes beyond that 30-month time period, it may be possible to get your charges withdrawn because your right to have your case heard within a reasonable period of time has been breached. This is a constitutional argument that you should speak to your lawyer about. That brings up the next question, which is, what are the key court appearances that you're going to face for your legal process? Now, as your criminal case proceeds through the court system in Ontario, you're going to face a series of court dates. And these court dates are as follows. One, it's called the first appearance. This is the first time you appear before the court. This is not a trial. Other court dates that you're going to face are court dates that are called to be spoken to or set date appearances. Now, the case against you is going to take time. For example, your lawyer needs to get all the evidence, prepare a defense, etc. The same is true of the Crown prosecuting the case against you. They need time to prepare the case against you, to respond to your lawyer, etc. Now, the courts require updates to the process to ensure that the process is moving along. These updates are heard in court, and these court dates are called to be spoken to or set appearance court dates. The next court date that you would have is something called a Crown pretrial. And a Crown pretrial is a resolution meeting that's held between the Crown and your lawyer. If you don't have a lawyer, you'll be represented by duty counsel. And at this meeting, the issues surrounding your case will be discussed and potential case resolutions will also be discussed. There will also be potentially a trial. And a trial is where the charges against you will be heard in a courtroom in front of a judge. And if the charges are very, very serious, in some cases, the case against you may even be decided by a jury. And lastly is sentencing. If you're found guilty, either you enter in a guilty plea or you are found guilty in a trial, you're going to have a sentencing court date during which the judge will decide in your sentencing. So let's go a little deeper into some of these court dates and specifically what happens at your first appearance in court. Now, the first time you appear in court for your drinking and driving or over 80 or your impaired driving by alcohol or drugs or your refuse breathalyzer charge is at a court date called your first appearance. Now, your first appearance is not a trial. The police officer does not need to be there. Your first appearance is the first time you appear before the court. And here's what's going to happen. You're going to tell the court whether you intend to plead guilty or not guilty. You're going to tell the court what your intentions are regarding a lawyer. If you do not intend to hire a lawyer, the court will give you direction to get legal advice, starting with duty counsel. And if you have not hired a lawyer, but you intend to do so, you're going to tell the court of your intention to hire a lawyer, and the court's going to give you a timeline to hire that lawyer. And third, the Crown is going to give you evidence that they have against you. This evidence is included in a package called disclosure. Now, this brings up the next question. Do you have to attend your first appearance? Now, if you've hired a lawyer, then no, you don't need to attend your first appearance because your lawyer will attend on your behalf. Now, if you have not hired a lawyer, then yes, you need to attend your first appearance. A lot of clients ask, will the police officer that charged you, will he or she be at your first appearance in court? And the answer is no. The police officer is not required to be at your first appearance. If your case goes to trial, then yes, the police officer that charged you will be called upon to give evidence that he or she has against you. Now, I've mentioned a few times disclosure. So that brings up the question, well, what is disclosure in a criminal case? Now, disclosure is incredibly important, and disclosure is all the evidence that the Crown will use against you as they try to convict you on your DUI charges. And disclosure includes all the police officer notes, written statements, witness statements, technical documents, including the notes from the breathalyzer technician. And lastly, brings up a really important question, and this is incredibly important, which is, are you entitled to all the evidence in your case? And the answer is emphatically yes. And it's important to know that your disclosure that you get at your first appearance, it may not be complete. It is critical, absolutely critical to get complete disclosure, because only when you get all the evidence about your case can you properly assess your case's strengths and weaknesses in order to mount an effective defense as you try to beat your DUI charge.